So I brought you down here on these status hearings for a particular reason. One of them is so you would understand what's involved in getting your discharge, and you've viewed that tape. The other reason that you've all been brought down here is because you have completed a statement of intention, which indicates that you have a car or some type of property which is subject to the claim of a bank or a car financing company. And you have to do certain things about that. And I want to make sure you understand what those things are and what your options are. And once I'm done giving this little talk, I'm going to call each one of you up here and we're going to go over the individual subject of your case. But you need to understand what your options are with respect to this. And I'm going to assume that you all have cars, which may or may not be the case, but I'm going to assume you all have cars. You had to file a statement of intention which indicated what you intended to do with the car. If you were going to surrender the car, which just means give it back to the creditor. You were going to redeem the car. If you can redeem the car by making one lump sum payment to the creditor. Sometimes that's an option, rarely though, because usually it's more money than you're going to have. And you can't make a redemption over time. You have to give them a lump sum payment. And then third and more common thing that happens is you can reaffirm the debt. If you reaffirm the debt, it means that you will owe the entire amount of the reaffirmed debt to that creditor, notwithstanding the fact that you went through bankruptcy. So the best example of this would be you're making your car payments, you reaffirm the debt, and after the bankruptcy you fall behind on the car payments. And then you have to give the car back to the creditor. The creditor not only gets to take the car, but if the car isn't worth what you owe the creditor, which is often the case, the creditor can then garnish your wages, get a judgment, and get the entire amount of the debt. So it's very important that you understand what the consequences are for a reaffirmation. Most of you have sent your statement of intentions to the creditor. Some of you are going to come up here and tell me that you've heard from the creditor or that you haven't heard from the creditor. But generally, you'll get the reaffirmation agreement from the creditor. It's a big, long document. It's a complicated document. You have to be careful and read it carefully, and you're going to have to fill out what's called Schedule D. In Schedule D, you're basically explaining to the court why it is you can afford to make the payments and why the court should approve the reaffirmation. Because one of the things that happens is because you are not represented by lawyers, I have to approve the reaffirmation agreement. The judge makes that decision in terms of whether or not it's in your best interest, and if it's not just in your best interest, but in the best interest of any dependents you may have. When I look at that, I look at, for instance, what the value of the car is and what the debt is, and I also look to see whether or not the creditor has offered any concessions to you. Have they lowered the interest rate? Have they agreed to lower your payments at all? In a situation where, let's say the car is worth $5,000 and you owe $10,000 and the interest rate is 25%, and I look at your bankruptcy schedules and it looks to me like you have negative net income, then I'm going to be very careful and probably very wary of approving that type of reaffirmation agreement. So after we have these hearings today, I'm going to tell you, you need to contact your creditors, you need to talk to them about sending you a reaffirmation agreement. That's also a time to try to discuss with them whether or not they'll make any concessions, whether or not, because I can't guarantee that I will approve a reaffirmation agreement just because it's filed. I have a duty to look at whether or not it's in your best interest. We've been talking about cars. Sometimes if you own a house, the mortgage company will ask you to sign a reaffirmation agreement on the house. That doesn't require my approval, although sometimes they ask you to file it with the court, and it may come in front of me, and I may consider it if you ask me to do that. Generally, if it's the first mortgage on the house, there's really no issue because there's certain protections provided to you under state law. If it's a second mortgage on a house, you really need to think very carefully about whether or not it's in your best interest to reaffirm that debt. And by a second mortgage, I mean if you had an equity line of credit, if you don't get the same protections under state law for that, you want to be very careful about reaffirming that type of debt, because should you not be able to make your house payments, that creditor may have the right to come, and probably will have the right to come and ask you to pay the balance if you reaffirm on that second mortgage. So you really want to always think very carefully about that. One of the things I also want to discuss with you is what happens if when you, after this hearing, you call the creditor up and the judge said to ask you to send me a reaffirmation agreement, and the creditor says, we don't want to bother with that. Don't worry, just make your payments, everything will be fine. You really need to ask them to tell you that in writing, because you don't have any record of that, and if the things should change later, there could be an argument about it. You ask them to send you a letter that says that. And if they then don't send you the letter, you send them a letter. And you send it, basically registered mail. And in the letter you say, "Dear creditor, on such and such a date, I spoke to such and such a person, and they told me you were not interested in sending me a reaffirmation agreement. And this letter confirms that you didn't ask me for a reaffirmation agreement, and I haven't reaffirmed the debt, but you told me I could keep the car." You want to make sure you get that in writing somewhere. And when you talk to the creditor's representative on the phone, you want to make sure you ask them for their name and the mailing address. You can't just assume that things are going to happen based on what's said on the phone. Probably things will be fine, but that's why you need some kind of record. The other thing you want to be aware of is if you come back and you convince me that reaffirmation is what you need to do, and it is in your best interest, and you can afford to make the payments, and then a month later something bad happens in your life and you can't make the payments, you can still basically cancel that reaffirmation. It's called rescission. You can rescind the reaffirmation agreement. But you have to do that within 60 days of having filed it with the court. So you need to keep track of the date that it's filed with the court, and sometimes that will be that the creditor will actually mail it into the court. So you need to keep track of that, and up until 60 days after that date, you can just send the creditor a letter. Again, I would send it by certified mail or by registered mail saying, "Dear creditor, I've reconsidered, I don't want to reaffirm the debt." And you should also send a copy of that letter to the court so we have a record down the road. Now, if you don't reaffirm the debt, there's a good chance, especially if you're not making your payments, that the creditor will come get the car, but at least you won't owe them anything else. So just remember you have that right to rescind. The last thing I want to caution you about is sometimes creditors will wait until after you've received your discharge, and then they'll call you up and they'll say, "Okay, time to enter into a repayment agreement." Under no circumstances should you do that for an existing debt. Reaffirmation has to be taken care of before you get your discharge, and it has to be approved by the court. If a creditor contacts you and says, you need to enter into this repayment agreement after you get your discharge, and it'll be good for your credit rating, and you better do it or else, it's a violation of your discharge injunction. They're not to do that. You should notify the court. You can file a letter with the court saying, "I've been contacted by this creditor. They've been demanding that I do whatever." That happens very rarely. The creditors generally know what the rules are, and they won't do that. But you absolutely should not do that. Okay, so that's kind of the overview of why I brought you in here. What I'm going to do now is call each one of your cases, and we're going to discuss your particular situation, and there'll be some orders issued following the hearing, and hopefully it'll be relatively easy to follow and to understand. All right, so let's call the first case.